This great and well-experienced judge declares that in all his time he never knew two questions made upon rights merely depending upon the common law, and warmly laments the confusion introduced by ill-judging and unlearned legislators. But if, he subjoins, acts of Parliament were after the old-fashioned pained by such only as perfectly knew what the common law was before the making of any act of Parliament concerning that matter, as also how far forth former statutes have provided remedy for former mischiefs, and defects discovered by experience, then should very few questions in law arise, and the learned should not so often and so much perplex their heads to make atonement and peace by construction of law between insensible and disagreeing words, sentences, and provisos, as they now do. And if this inconvenience was so heavily felt in the reign of Queen Elizabeth, you may judge how the evil is increased in later times, when the statute book is swelled to 10 times a larger bulk, unless it should be found that the penners of our modern statutes have proportionally better informed themselves in the knowledge of the common law. What is said of our gentlemen in general, and the propriety of their application to the study of the laws of their country, will hold equally strong, or still stronger, with regard to the nobility of this realm, except only in the article of serving upon juries. But, instead of these, they have several peculiar provinces of far greater consequence and concern, being, not only by birth, hereditary counsellors of the crown, and judges upon their honour of the lives of their brother peers, but also arbiters of the property of all their fellow subjects, and that, in the last resort, in this their judicial capacity, they are bound to decide the nicest and most critical points of the law, to examine and correct such errors as have escaped the most experienced sages of the profession, the Lord Keeper and the judges of the courts at Westminster. Their sentence is final, decisive, irrevocable. No appeal, no correction, not even a review can be had. And to their determination, whatever it be, the inferior courts of justice must conform, otherwise the rule of property would no longer be uniform and steady. Should a judge in the most subordinate jurisdiction be deficient in the knowledge of the law, it would reflect infinite contempt upon himself and disgrace upon those who employ him. And yet the consequence of his ignorance is comparatively very trifling and small. His judgment may be examined, and his errors rectified by other courts. But how much more serious and affecting is the case of a superior judge, if, without any skill in the laws, he will boldly venture to decide a question upon which the welfare and subsistence of whole families may depend, where the chance of his judging right or wrong is barely equal, and where, if he chances to judge wrong, he does an injury of the most alarming nature, an injury without possibility of redress. Yet, vast as this trust is, it can nowhere be so properly reposed as in the noble hands where our excellent Constitution has placed it, and therefore placed it, because, from the independence of their fortune and the dignity of their station, they are presumed to employ that leisure which is the consequence of both, in attaining a more extensive knowledge of the laws than persons of inferior rank, and because the founders of our policy relied upon that delicacy of sentiment, so peculiar to noble birth, which, as on the one hand it will prevent either interest or affection from interfering in questions of right, so on the other it will bind the peer in honor, an obligation which the law esteems equal to another's oath, to be master of those points upon which it is his birthright to decide. The Roman Pandects will furnish us with a piece of history not unapplicable to our present purpose. Servius Sulpicius, a gentleman of the patrician order and a celebrated orator, had occasion to take the opinion of Quintus Mutius Scaevola, the oracle of the Roman law, but for want of some knowledge in that science, could not so much as understand even the technical terms, which his friend was obliged to make use of. Upon which Mutius Scaevola could not forbear to upbraid him with this memorable reproof, that it was a shame for a patrician, a nobleman, and an orator of causes, to be ignorant of that law in which he was so peculiarly concerned. This reproach made so deep an impression on Sulpicius that he immediately applied himself to the study of the law, wherein he arrived to that proficiency, that he left behind him about 180 volumes of his own compiling upon the subject, and became, in the opinion of Cicero, a much more complete lawyer than even Mutius Scaevola himself. I would not be thought to recommend to our English nobility and gentry to become as great lawyers as Sulpicius, though he, together with his character, sustained likewise that of an excellent orator, a firm patriot, and a wise, indefatigable senator. But the inference which arises from this story is this, that ignorance of the law of the land hath ever been esteemed dishonorable in those who are entrusted by their country to maintain, to administer, and to amend them. But surely there is little occasion to enforce this argument any further to persons of rank and distinction, if we of this place may be allowed to form a general judgment from those who are under our inspection. Happy that while we lay down the rule, we can also produce the example. You will therefore permit your professor to indulge both a public and private satisfaction, by bearing this open testimony, that in the infancy of these studies among us, they were favored with the most diligent attendance, and pursued with the most unwearied application, by those of the noblest birth and most ample patrimony, some of whom are still the ornaments of this seat of learning, and others at a greater distance continue doing honor to its institutions, by comparing our policy and laws with those of other kingdoms abroad, or exerting their senatorial abilities in the councils of the nation at home. Nor will some degree of legal knowledge be found in the least superfluous to persons of inferior rank, especially those of the learned professions. The clergy in particular, besides the common obligations they are under in proportion to their rank and fortune, have also abundant reason, considered merely as clergymen, to be acquainted with many branches of the law, which are almost peculiar and appropriated to themselves alone. Such are the laws relating to advowsons, institutions, and inductions, to simony and simonical contracts, to uniformity, residence, and pluralities, to tithe and other ecclesiastical dues, to marriages, more especially of late, and to a variety of other subjects, which are consigned to the care of their order by the provisions of particular statutes. To understand these aright, to discern what is warranted or enjoined, and what is forbidden by law, demands a sort of legal apprehension, which is no otherwise to be acquired than by use and a familiar acquaintance with legal writers. For the gentlemen of the faculty of physic, I must frankly own that I see no special reason why they in particular should apply themselves to the study of the law, unless in common with other gentlemen, and to complete the character of general and extensive knowledge, a character which their profession, beyond others, has remarkably deserved. They will give me leave, however, to suggest, and that not ludicrously, that it might frequently be of use to families upon sudden emergencies, if the physician were acquainted with the doctrine of last wills and testaments, at least so far as relates to the formal part of their execution.